So now we're going to start diving into more contractual language. We're going to spend pretty much the rest of our time together reading a contract, then dissecting it. What's good about it, what's bad about it. Because this is what we have to do in our day-to-day practices. So before we do that, the first one we're going to do is a patent license. So let's talk about patent licenses. How is a patent license different from other contracts and also different from other types of licenses? Well, the first thing that makes a patent license unique is you have to list the patents, right? You have to describe them, usually by their registration number. That's the easiest way. You also have to describe the potential uses, the permitted uses of the patent. Why is it licensed? Okay. And typically you would describe the territory. An interesting thing about patents is in US law there is a concept called abusive patent. For example, if I have a patent and there's 10 years remaining on the life of that patent, but I execute a license in favor of you for 12 years, i.e. more than I have to give, that's called abuse of my patent, and it can invalidate my patent. So if you were a tricky licensee and you knew I had only 10 years left on my patent, you could take a license from me for 12 years and then sue me to invalidate my patent and then use it for free, right? So in patent law in particular, it doesn't really apply to trademarks or copyrights, but in patent, if the owner grants a license greater than that which he has a right to grant, it can invalidate the whole patent as to the whole world. So describing, for example, the territory, I brought this up in connection with territory because patents, all intellectual property is territorial. If I have a US patent and I grant a license to you for Canada, I'm abusing my patent rights. Could invalidate my patent as of the whole world. And I think this is just a place where lawyers can get careless, not thinking, the client says, I'm only going to have one licensee. They can sell the thing in the whole world, fine. But my license is only going to say US because you don't have more than that to grant. You might agree that you won't sue them for practicing the invention in France, but you can't grant them a license for France because you don't have the right to do that. So we have to pay attention as lawyers about where patents are concerned, what does our client own? Because we can't cause them to grant a license that's greater than what they have to grant. Typically also, as we talked about earlier, in a patent license and all IP licenses, you would speak to whether the license is sub-licensable. I think probably the better answer is if you're silent on that issue, it's sub-licensable. In a patent license, you would also typically have, unlike the other intellectual properties, or more importantly than with respect to the other intellectual properties, if you're the licensor, you want it to contain an obligation that the licensee mark products manufactured with the patent with proper patent markings, right? Manufactured under US patent number 1, 2, 3, 4, 5, 6, etc. If you manufacture products of a patent without the patent number on it, that too can invalidate the patent. So as the licensor, we want to make sure that the licensee has a contractual obligation to put patent markings on the product. And then finally, typically in a patent license, like an IP license, you would have representations and warranties. Let's switch our perspective from licensor to licensee for a minute. If I'm the licensee of a patent and I'm getting the agreement from you, what kind of representations and warranties do I want as the licensee? I'm licensing your patent. What do I want you to represent to me? What kind of representation?
First of all, that I am the owner of the patent.
That you're the owner of the patent, correct. What else?
Ownership.
Yeah. Huh?
What stands behind the patent? What's protected?
What do you mean? I'm the licensor, and I say I have patent 1, 2, 3, 4, 5, 6. And you want to know what stands behind it? My answer would be, look, read it. So I'm not sure what I know. I'm not sure I know what you mean. What stands behind it? Okay. What other representation or warranty do you want from me? Ownership. There's another real big one, goes with ownership. Non-infringement. Not only do you own this patent, but it doesn't infringe anybody else's patent, right? That's a big representation you want as a licensee. You own it, it doesn't infringe. What else? What do you want to be sure of when you're taking a license to a patent?
Usable.
Who said that?
To be usable.
Yeah. To be
I
usable.
want to use that patent, so I need to be sure that it's usable.
And I know that it works, right? You're licensing me a patent for an adding machine. I gotta know it works.
Yes.
When I exercise this patent, I get an adding machine, and it, when I put 1 + 1 in it, it spits out 2, not 6.
Usability.
Yeah, usability. Yeah. Those are 3 big ones. All right, so we've scratched the surface on how a patent license is different from other contracts and other licenses. Now we're going to read one. So the first contract we're going to read today is very short, so we don't really even need to take a break to read it. In the materials that Christina gave you for use in class today, it's on page 31. Exclusive Patent License Agreement. It's 1 page long. So take a minute to read it. I'm going to refresh my recollection on it myself, and then we'll talk about it.
Sorry, what page was?
It's on page 31 of the PDF. There's page numbers in the lower right-hand corner. see people
Can we
reading
go
them.
on?
Okay, let's start. So, who's ever had a client say to them, I want you to do a contract for me. I found this one on the internet. Why don't you use it as your starting point? Can you just give this a quick look and make sure it's okay?
Yeah, of course.
And really, from our perspective, again, that doesn't remove any of the risk of something bad happening to the client. What does it do? It just moves the risk from them to me. Can't do it, right? So every contract we'll talk about today is from my real practice, including this one. I'm just going to tell you right up front, I didn't draft this one. It's not very good. And I think the client gave it to me in that context, like, hey, I found this on the internet, I want to license a patent, can we just use this, right? So what do you say to the client? What's good about this, what's bad about it?
It's good because it's short and practical and simple to understand.
True.
But
We have to add some.
there is space to improve it.
Yeah.
At least, what about consequences after termination? It describes the cases when terminate. The licensor has the right to terminate or the licensee.
Yeah.
But what happened
All right. And
after?
so, for example, the client, and I'm the client. What do you mean? What happens? It's over.
The client, you are the licensee or the licensee?
Let's say I'm the licensee.
Licensee.
Yeah.
Because the contract should also hold some warranties and representations, which there is space to add. If I find out an infringement which makes me allow me to terminate this contract, then to describe the right of me to be indemnified
Oh, okay.
from
So
this
that should be,
relationship.
regardless of termination, I want indemnification,
Yeah.
either before or after it's
But
terminated.
because in this agreement I have based a business plan for myself, so which will not be realized if I have to terminate.
Yeah. So this says.
I lose incomes. I will lose incomes.
Yeah. Okay. So I'm a licensee. If I license this patent from you, I'm going to build a factory. I got to make adding machines. I'm going to make tools. I'm going to build a factory. I'm going to hire people. And then if it's terminated because it's infringing,
I find out that it's infringed.
what happens to me? Okay. So we have to take care of that issue, right? Because this says it can be terminated.
Just that.
Yeah. Period. But not anything that happens after. What's another thing that could happen after termination? We'll move on to other issues in a minute that I have to be worried about. Not just indemnity. What else? I'm going to start manufacturing typewriters. What's the term of this thing? How long does it last?
It doesn't have any
That's
term.
okay.
That's what my point.
No term.
No term.
So that could be good for me as the licensee. Well, but it says it can be terminated at any time.
And anytime, yeah, that's the problem.
Especially in a patent license, because a patent license, to me, is probably the most likely intellectual property license that's going to cause me, as the licensee, to incur cost. Namely, building a factory to make whatever it is. Cars, typewriters, adding machines, cell phones. So it can be terminated at any time.
Yeah.
Bad idea.
And also,
But
it doesn't say how long does the patent.
how long does the patent last? What's the remaining lifespan?
What is the
I could check that in the public records.
Okay, but it doesn't have any in the agreement. We should ask our client about that.
Yeah. And that might be a representation and warranty we want.
And then in the first paragraph it says it's licensed through Wall.
Right. Well, let's hold that thought because I still want to talk about what happens after termination.
Okay.
Right? What else do we have to worry about after termination?
We do not have the law governing the contract.
Okay, that applies during the contract and after, I would think, right? After termination, if I take this license and I start manufacturing adding machines, but the licensor can terminate it at any time, even if I'm okay with that as a general matter, which I shouldn't be, but let's say, okay, you can terminate it at any time. But as licensee, once you terminate, I'm going to have a warehouse full of typewriters or writing machines.
What would happen with them?
What happens to those? Because if you terminate the patent license, I can't sell them. So as a licensee, I need that in the contract. What happens after termination? This is a very common provision in an IP license where physical goods are at issue, right? What happens to those physical goods? I have a client that's a furniture manufacturer.
The effective costs of the licensee can be asked for them?
He could. I mean, so there's a lot of ways to approach this, right? So I have a client that's a furniture designer. He designs high-end patio furniture. So like, you have Crate and Barrel here? Do you have that store? It's a big, they sell, like my client will design a patio set and they'll sell 100,000 sets of that patio furniture per year for $3,000 each. It's a huge business. And we're typically able to get into the contract that, okay, once this license ends, you will give to me the remaining inventory as long as I pick it up. Because you can't sell it anymore. And I don't know why the licensees in those situations will agree to that, because they're just not thinking clearly, I think. Because it's millions of dollars worth of inventory that my client gets for free at the end of the license. But as the licensee, what you might say is, okay, after termination, I get a year to sell off inventory. I can't manufacture any new ones, but I get a year to sell it off, as long as I continue to pay royalties on it. And then, what happens? You always have to get to the, and then what? What if there's 10,000 units left? Well, either I have to destroy them, or I have to give them back to you. You have to pay me at cost, like my expenses. These are the business issues that we as the lawyers don't decide, but we have to point out to the client, like, wait, when it ends, you're going to have a warehouse full of adding machines. And what do we do?
This is in the case of normal termination, as provided in the contract.
Yeah, or, let's say, so in this conversation, so if I'm representing the licensee, I would say, okay, I want a year to sell off the inventory after the termination of the license. And then I'll destroy whatever's left. I'm not really going to do it, but I'll let the contract say that. I'm going to sell it out the back door. No, but that's what they all do. So then I'll destroy the inventory. Then as licensor, now put your licensor hat on. That's reasonable, except what? In what circumstances should the licensee not have the right to do that? To sell off the inventory after it ends.
The licensee.
The licensee. If I'm the licensor,
If the production is not referring to the patent, if there are defects,
yeah.
things
If
like that.
the product is defective,
Yeah.
if that's the reason I terminated the license, no. Or you're exceeding the scope of the license. I granted you a license for Texas, and you're selling product in Texas, Illinois, and Oklahoma. If basically, licensee, if you're in breach, if that's the reason this ends, you don't get that sell-off right. That's reasonable, I think. Okay. The other thing this doesn't have is, it would be more important if this were a longer agreement, I think, but typically in a contract, in the termination provision, it says, in XYZ event, this contract can terminate. But after termination, these provisions survive, right? Because termination means it all goes away. But you want certain provisions to survive, like indemnity. Assume we get indemnity in here. I don't want termination to just eliminate that indemnity obligation from the licensor to me as the licensee. Let's say we get a representation that they own the intellectual property, it doesn't infringe, which is another thing we want as the licensee, and an indemnity from them. If it's infringing, you indemnify me. Well, if I don't get a survival provision in here, and there's a $100 million infringement lawsuit, what does she do? She has the right to terminate at any time. Terminate. The whole thing goes away, including the representation and including the indemnity. So even if I'm willing to allow the termination at any time, I have to put in a provision that says, yes, but on termination, certain things survive. Okay, now, let's segue to one of your other issues. Maybe, I hope you remembered them.
Yes, of course. The first paragraph says that the license is given for through the law, the whole law.
The whole world.
Yeah, and the patent is a territory, right?
Yep. So as a licensee, you know what? I might not take issue with that. I know better. There's really no consequence to me. He granted me more than he had the right to grant. I know he doesn't have a good lawyer, but
still we come to the same results. Because I find out later and still we come to the fact I terminate and I ask for indemnities. So,
you terminate why?
no, if it's not true that he has the right to.
Well, which he doesn't. I mean, we know he doesn't, because a patent is good only in the territory in which it's issued.
But it doesn't bother me.
Yeah, but it doesn't bother me because no real negative consequence to me.
I
But-
go for invalidation.
If I were representing the licensor and the licensor brought me this document and said, "Can you just give this a quick look?" I would say that would be one thing I would say. You can't grant a worldwide license.
Can grant something that you don't have.
Yeah. Okay. What else is good or bad about this license?
There's no description of it.
Of the invention?
Yeah.
It's got a patent number, right? I mean,
No,
that's not a
it's
real
numbered,
patent number, but
Yeah, so.
I think that would be good enough. It's got a patent number. If I want a description, I can go look at the patent. Yeah.
It says arbitration, but it doesn't say which arbitration. And not which law.
Let's talk about arbitration for a minute. So, in the United States, here's what I say about arbitration to my clients. What I say is that arbitration used to be acceptable for a number of clients because people thought that, and it was the case that arbitration was quicker and cheaper than full-on litigation. But in today's world, that's not really the case because lawyers have found a way to earn just as much money through arbitrating as they could earn through litigating. It's okay, you know, it's like, if you're a lawyer, you can trash lawyers, right? Because you are one. That's what I do to my clients all the time. I tell them, look, arbitration in the United States, it doesn't matter anymore. Why agree to it? Because it's going to be just as expensive, take just as long as litigation. You can thank the lawyers for that, but that's what's going to happen. And at the end of the day, particularly with a clause like this, it doesn't specify where, under what rules, what evidentiary rules, you know, no trial by jury. So if you want arbitration, let's, you know, add another page and a half to this one-page agreement on that topic alone. So that's what I say about arbitration in the United States. So what about arbitration in your part of the world? Do you recommend it or not? Is it good? Is it not?
We recommend it because
Why is it good?
We recommend it. It's,
faster procedures.
Faster.
Yeah.
Okay, so it's still faster. Okay.
it's
It's
more
comparing
about
with
the
the
matter of
partners.
credibility.
What do you mean?
Not because not resolving the issue in state of one of the parties. So let's resolve the issue in Vienna, for example.
Okay.
Or in Paris, because it's a neutral, let's say.
Right. You can specify a neutral territory.
Yeah.
Whereas with litigation, I often have clients come to me on the choice of law provision, putting arbitration aside for a second. So let's say I have my client in California, they're entering into a contract with somebody in New York, and they're not talking about arbitration, they're talking about choosing venue for litigation if there is one. They say, well, choose a neutral place, like Illinois. Well, you can't really do that, because in Illinois court, you go to an Illinois court and they're going to say, what are you doing here? You're in California, you're in New York, and there's nothing about Illinois about this, and they're going to kick you out because they don't get paid more to litigate your case in front of that judge. It's a drain on their resources. They won't hear it. So I have clients all the time say, well, just pick a neutral place. You can't. You're in California, they're in New York, it has to be one or the other. But with arbitration, you can.
It works, yeah.
In Vienna, sure, they'll be happy to talk to you. Why? Because they charge $800 an hour. So, okay. Anybody else have thoughts on arbitration in your part of the world? She likes it, she recommends it.
I don't like,
Why?
but doesn't function.
It doesn't function? Why?
At least in Macedonia, doesn't.
Why?
How? I mean, what do you mean?
It's the same job, it's the same,
There is not much. There is not much arbitration, so it doesn't go.
You mean there aren't arbitrators?
Yeah, there are arbitrators. There is arbitration. The one that is in the Chamber of Commerce, but it doesn't function. I mean, there is.
You mean that you hire them and they don't do anything?
No cases going over there. So.
Is that because nobody goes there, or because?
Nobody goes there.
Well, what if you went there? Sounds to me like a good situation. They're sitting there waiting for cases to arbitrate. Why wouldn't you go?
Yeah, but they have the expenses like rooftops. So.
Okay, much more expensive than going to court, which is true.
There is.
For all arbitration, if you hire the arbitrator, you have to pay them, right?
the time is more important for me in such cases. I would recommend it, but it's lack of information, and there are people in our country at least are still not very well known on this way. So
As
much
arbitrators.
advertisement of this other type of, but in some contracts of mine of big projects, I have suggested arbitration that has been accepted by the parties because in big businesses the time for them is money. So,
Okay.
and at least theoretically, the arbitrators are licensed, so it's supposed that are well prepared. So
Okay.
regarding quality, no issue. You win in timing.
Right. So another potential benefit of arbitration is, at least in the United States, if you're litigating, you get assigned to a judge. They may know something about your subject matter area, they may not.
Yeah.
In an arbitration clause, you can say, the arbitrator must have at least X experience in this area.
Expertise. That's the whole point of the arbitration.
Yeah.
But just the main problem is that you need to meet the conditions in order to go to arbitration, because firstly both of the parties needs to agree upon that, and in my country at least that's almost impossible.
To get the parties to agree?
Yeah, because they always one of the parties does not want to go there because they want to have that home advantage. They want to be in their court.
Yeah, although, I mean, I suspect that in those disputes between clients, one wants it, one doesn't, gets resolved the way everything gets resolved. One party has more leverage and gets its way, or, you know, eventually the contract either says arbitration or not, depending on who won.
But in my opinion, that's a great way to resolve all the problems, especially because that you have really a person of expertise who can actually resolve that problem, and not the judge who may know or may not know anything about it.
Okay, so I like this part of the discussion because in the United States, I told you my opinion. It's sort of like, no, there's really no benefit to it. It's not any cheaper, it's not any faster, and by the way, the decision might be arbitrary, because I think my view of arbitrators is, no matter who's right and who's wrong, they try and split it down the middle, right? Oh yeah, you're owed $100 million. He's got a good case, but 50 will do.
They're doing a compromise.
Huh?
They're doing a compromise.
Compromise, yeah. So I don't recommend arbitration, but I lay it out for my clients. This is what I think. Now you make the choice.
Why there is no difference in US for at least timing issue?
No, lawyers have found a way to make it take just as long and cost just as much money.
Smart boys, smart guys.
Yeah. Interestingly, in most of the places I teach in School of American Law, in the former Soviet republics, people like arbitration because the courts are so corrupt. I didn't hear anybody say that.
This, Professor, but that's the background of all this story.
We can be honest.
I didn't want to mention it.
Are you still recording?
Yeah, right. Yeah, but they can't see your face. They can only see mine. Yeah, so, I mean, I understand that, you know, and to me, it would seem it's counterintuitive. I would think in the United States, it would be much easier for me to bribe an arbitrator than a judge. Because I know if I try to bribe a judge, it's criminal. I could go to jail.
All of the judges are corrupt, or
In the United States,
and the lawyers
the judges are not corrupt in the United States, for the most part. I mean, you could find a judge. When I was in high school, I had friends who were in politics, and if I got a speeding ticket or something, they'd pay the judge. Judges will take money to fix a speeding ticket or something, but to my knowledge, in a big business dispute, they can't be bought.
They are paid well. It varies on maybe.
No, not as compared to lawyers.
It's more like a matter of integrity than paying well.
No, because they know somebody's watching and they go to jail. It's a criminal offense. So, okay. What else about this patent license? Let's spend another 10 minutes or something on it. There's a lot more to talk about. What else is good or bad about it?
It's good because it's very simple the way the way of payment. 1, 2,
The payment.
3. It's simple, understandable.
Royalties shall be paid on a quarterly basis. Minimum annual royalty, $1 million.
No, I mean a paragraph above. 40% of the net selling price is the first piece. Then the second, or if the products are disposed in another manner than sale, the royalty shall be calculated on customary price for similar goods.
Yeah.
And 3, if any products are sold to a corporation that is controlled or subsidiary of the licensee, the royalty shall be determined by the resale price.
Yeah.
Okay, let's us work after that determination, but our simple determination, what happened in each case.
Yep. So this is an important point, again, as between the U.S. and international. There's a huge problem with this paragraph from the perspective of United States law that I suspect does not exist in your territories. 40% of the net selling price. What's meant by net? What gets
Net
deducted
income
from gross to
after
reach
taxes.
net? Huh?
Net income after taxes.
After taxes. And that's it?
No.
What else?
Expenses.
Expenses.
Yeah,
All the expenses, the cost.
Yeah, all the costs.
So,
You may have rented the place that you go with your activity, and you said minus the rent, minus taxes, minus the salaries, minus everything that you spend on that.
That's an extra cost.
Yeah.
Minus lawyers.
yeah, minus everything.
Operational costs.
So,
The operational costs, everything.
in most of Eastern Europe, or in most of the places I teach, they tell me that net has a legal definition, right? It's gross minus taxes and maybe something else, but not all this other stuff. In the United States, this definition is unacceptable to me as the licensor, because the licensee can deduct anything. You said like the cost of the place, right?
Yeah.
So the licensee has a factory. And on this side of the factory, he's manufacturing adding machines. And on that side of the factory, he's manufacturing automobiles that have nothing to do with me. But from my royalties, he deducts the cost of the whole factory. And from that licensor's royalties, he deducts the whole cost of the whole factory. This issue became very publicly debated in the entertainment industry in the United States. Maybe it's almost 20 years ago now, where the motion picture industry would say that people who participated on a royalty basis in feature films would get paid on a net basis. And until 20 years ago, in the history of Hollywood, there was literally never a movie that made a profit, because the movie studios would deduct everything. Every film lost money, even though these companies were very rich. So 20 years ago, a writer who was participating on a royalty basis in a film called Coming to America, I don't know if you've ever seen it, Eddie Murphy movie from 30 years ago, he filed a lawsuit and he caused the practice to change. But the bottom line is, at least in America, and it sounds like here too, in your places, your territories too, you have to be very specific about what you deduct from gross to reach net if you're the licensor. Because if you don't, if you're not specific, the licensee will deduct everything, and there will never be profit from which you could get 40%. So just saying net selling price to me would be a non-starter for this agreement. I would tell the client, if we don't change this, you're getting nothing except the $1 million minimum, because there's a minimum in here. But there would be no royalty. What else about this agreement? also on the royalty language. It's the third paragraph about royalties. This is kind of a pet peeve of mine as a lawyer, but I'll tell you my thoughts from a drafting perspective. The paragraph that begins, royalties shall be paid on a quarterly basis. Huh? Quarterly basis, yeah. If the royalties aren't paid, who's in breach?
If are not paid,
Yeah, who's in breach?
licensing.
That's what one would think, but what does this sentence say? The royalties shall be paid. If the royalties aren't paid, the royalties are in breach. Because this is a passive sentence. It's horribly written from my perspective. The royalties shall be paid? No. Licensee shall pay royalties.
Even the languages.
Huh? I mean, to me, I'm always worried. I tell clients all the time, the person I'm worried about is the creative litigator. If we ever get into a dispute about this, I don't want anybody to be able to argue any sentence means anything other than you want it to mean. If this sentence is in, the creative litigator is going to argue the licensee didn't pay, but the licensee is not in breach because the licensee doesn't have an obligation to pay. The royalties have an obligation to get paid. If they didn't get paid, go talk to the royalties. Clients don't like that because it is kind of a lawyer's argument, right? But to me, that's just like, I don't like that.
Sorry, it's above. Licensee shall pay a royalty of 40%. It's in paragraph above. Licensee shall pay a royalty.
Yeah. So why?
Sorry.
So why can't that say? Go talk to them.
It's plural.
It's poor drafting.
We are international.
I don't know if I were representing the licensor. Well, I don't know that I would fix that because there's so much else to do in this contract. But it's. I thought
Better start a new one than fix this.
I would throw this out. Yeah. What else about this contract now that we're done with the royalty provision? What do you think about
Customary price.
What do you think about the paragraph that says accountings will be considered final if the licensee receives no objection? That whole paragraph. No, just that sentence. As if I'm representing a licensor, and the licensee wants this provision. If I send you a royalty statement and you don't tell me within 1 year, that's it. This to me is about a breach of contract. If the licensee doesn't pay royalties or pays them inaccurately, it's a breach of contract, right?
Yeah.
In Illinois, the statutorily prescribed statute of limitations for a breach of contract action is 6 years, right? So without this sentence in the contract, if I'm the licensor and the licensee reports inaccurately, I have 6 years to chase them for it. What's the statute of limitations on a breach of contract action in your territory?
Depends on the project.
This is an IP license. What do you think it is? Ballpark it.
3, 5 years.
3 or 5 years. So what the licensee here is doing is changing the time, the statute of limitations, from 3 or 5 or in Illinois 6 down to 1. What do you think about that? If you're the licensor, is it good or bad?
It's bad. It's short
bad.
time.
Short time, right?
Prolong it.
What I usually do, what I usually argue on this point is, if I were representing the licensor, I would talk to the licensee's lawyer and I would say, look, there's a statute of limitations that's by law. We have a legislature. They spend a lot of time with public hearings, with committees, with the vote. The people have spoken. For a breach of contract, somebody should have 6 years. That's what the law says. Why should we change it? Why should we overrule the judgment of the legislature and the governor of the state in order to change it to 1 year? And often that can win. Yeah.
But if they don't tell us the real accountings, if they give us something else than the real accountings, then they're doing a fraud.
So you could sue them for fraud too. Yeah. This is, again, the creative litigator, right? Maybe I can't get you for breach of contract, but I'll get you for fraud.
For fraud.
Yeah.
And then
I'd have longer time.
Yeah, and I will ask revenue office to come.
Yeah. That's fair enough.
Trouble.
Fair enough.
Isn't that invalid? Like either you put it 1 year, 2 years, or whatever. If you don't respect the
The law.
No.
time term.
In the U.S., you can specify that the contracting parties can agree to a shorter time. You think in your territory,
We have it 10 years for
Basic.
contract breaches for indemnification, and that has to do with the right to apply to the court.
yes,
To apply the suit.
and the parties can't agree to change that.
No, we cannot.
In the U.S., you can.
The code of
That's
civil procedure.
Yeah, in the U.S. you can change. You can say 1 day. If I give you the statement and you don't object, by the next day, foreclose forever, and that would be enforceable. I mean, nobody would agree to it, right? But you could.
Yes, basically it depends between the party what they agree, but the law defines maximum and minimum of the action.
Yeah, not in the United States.
Right,
The law- The law would only apply if the parties didn't agree otherwise. Let's talk about one other provision in here, at least one more, and then we'll talk about what's missing from here. What about the very last sentence? The very last sentence on the bottom of the first page. I'm sorry. The second to last paragraph.
Yeah, this prior.
This license may not be assigned. This license may not be assigned or transferred by licensee except with the prior written approval of licensor.
Starting with your idea to put everything in the contract, why to do the next step, it's better to define it. It's not allowed to sublet it, or it's allowed to sublet it.
So what does the law say?
To save time and to save space.
What does the law say in your territory? If the contract is silent on this issue, can it be assigned or not?
No.
I'm not talking about IP rights. I'm talking about a contract.
No.
Cannot assign.
You should define it. So, I mean, you cannot sublet it.
So that's another difference between. If that's the case, then that's another difference between the U.S. and your territory. If a contract is silent on whether I can assign it, I can assign it. Freely assignable unless prohibited.
You can use more
It's
rights
not
than
prohibited,
are
it's
given to
allowed.
you.
Well, true, but I could give them to you. Whatever I have, I could give to you.
What is not prohibited is allowed.
Yeah, but you don't.
Yes, right. What's not prohibited is allowed.
You don't have the right to transfer if not specifically said.
Yeah, so if you're doing business in the United States, again, you need to pay attention to that because the rule is the opposite. If assignment is not specifically prohibited, it's freely assignable.
Prohibited, it's allowed.
Yeah, on this point. Not always, but on this point. What's missing from this contract? A lot, right? From both sides' perspective.
Having present the price, yes, it's very simple.
The price is there, the royalty rate is there, the minimum is there.
What amount we are talking about is very simple.
Yeah.
Contract should be a little more.
The amount should be more? I mean,
No.
it's the same.
Yeah, starting from point of view of having present the amount here, it says
Yeah.
it's a huge amount, so should be the contract should be a little more professional than this simple.
Fair enough.
They are still fighting.
No, we're not fighting, we're just saying that it's the same like the states, you know.
She's distracting me.
Yeah.
Regarding this
Always.
paragraph, in the event of any improvement of the invention.
Yeah.
So maybe the language should be more clear. What does it mean improvement of the invention? Because it may be a new invention, it can go until then or in one point. From the perspective of the licensor in this case. So the lawyer of the licensor should be more focused on this.
Right, so that the contract doesn't actually grant more than the licensor wants it to, because this word improvement is vague, right? So in patent law, when you improve your invention, there's something called a continuation, or a continuation in part. You take the original patent and you say, oh, now I've improved it. Now there's this continuation. I've added a third ear to the Mickey Mouse ears, right? And then you can patent that improvement. I think it's appropriate to say in a patent license, okay, if I get any continuations, you get those too. But be more specific about it, so it's not just talking about improvements, which is a vague word.
But who gets to choose if it's an improvement or not? The authority?
Well, if you were more specific about it in the contract, then it just is or it isn't. If there's a continuation, which is a document issued by the patent office, it's either included or not. If you're vague about it and just say improvement, then who knows who chooses? You leave it open to dispute, which to me is bad lawyering. I never want there to be, I don't care what it says, any contract, I don't care what it says. I just don't want you to be able to argue about it later. If you can't argue about what it means after the fact, I've done my job. No matter what it says, good or bad. What's missing from this contract? Let me ask you this. So I think another difference between the U.S. and a lot of places I teach this course internationally is around the issue of attorney's fees. In the U.S., if we have a dispute between us and the contract is silent on the issue of who pays attorney's fees, everybody pays their own, regardless of who wins and who loses, and who was the bad guy and who was the good guy. What's the rule in your territories? The opposite?
Are we talking for a conflict
the
in
court
court,
will
the fees
decide
of the
the law.
attorney in court, or the fees for an agreement?
The court.
We have a dispute.
So, dispute.
Yes. We sign this contract a year from
We have it by law.
now. We sign this contract. We sign this contract a year from now. We wind up in a lawsuit about it. You win, I lose. Who pays the fees?
You
The loser pays the fees.
You the
Okay.
loser.
But the courts can decide if the fee can be higher or lower, depend.
No, we have some references for the fee. And if I give my fee to the court, they cannot move my fee.
I'm saying.
They cannot. They cannot. I
For
have an
example-
agreement with the client, and this agreement, and okay, they're asking also for the invoice, which is not. But the court cannot decide otherwise in our country.
Yeah. For example, I'm on a court, I'm winning the case, and I was having like 4 trials,
Yeah.
and I'm asking
Unreasonable fees.
fee for the 4 trials. The court can say, no, we didn't have 4 trials. You were.
But this is normal. You cannot go to the court for the fee for
It's
4 cases, and you are running 1 case there.
Yeah, that's
I have the
just
same case in.
so anyway,
I have the same case in the court. Like
So
the other party brought up a huge amount of legal
I
expenses,
think that.
but at the end the contract was for different legal expenses, not only for the court expenses. So the court decided just for the court expenses.
We are saying about the fee.
And then the court expenses the fee of the legal fee. And we're
The
talking
courts
about
can
this.
say, we have 5, maybe we have 5 trials, but we are going to we are saying that one that is lost is going to pay 3 trials. Fees for the 3.
so in the United States, what the rule is if the contract is silent on the issue,
Yeah, it's bizarre.
that's going to be on the exam. I'm not telling you the answer.
Huh? That's our time.
Okay, so
Sorry, how-
what we're going to do next, that issue's on the exam, but I'm not going to tell you the answer. Because I got tired of waiting. Anyway, what we're going to do now is we're going to take a break, and we're going to, during the break, we're going to read this trademark license. That's the next thing in the materials. 1, it's 2. It starts on page 33. And when we come back from the break, we're going to do with that license with what we just did with the patent license. We're going to dissect it, and we're going to talk about what's good and what's bad. All right? Thank you.